The court noted that the disproportional impact was due to the systemic injustice and not the administration of the Persistent Offender Accountability Act. So, and I think in Gregory, you're looking at the moment of between the decision to, I should say that it's, the point that we're looking at is the beginning, the special sentencing proceedings were 4 times more likely to result in death. So that is the point that we can isolate. But what Gregory took a lot of time to do was to remove that decision and look at basically what was left was the systemic factors. So it's the systemic factors that make the death penalty racist. And so I think the Persistent Offender Accountability Act is extra vulnerable to these systemic problems because we don't have the opportunity.
Yeah, there were systemic factors, but it really came down to the discretion of the court, right? In terms of whether they're going to impose a death penalty. I mean, there was discretion that was exercised in terms of what the death penalty was or was not going to be imposed. In the POA, we know that that discretion isn't there. That was, I think, what they keyed on in Nelson. We followed Nelson. The Supreme Court has denied review on those cases. What are we going to take from that?
Well, I think that the lack of discretion actually makes it worse.
Well, it may make it worse in your mind with regard to the imposition of it. But when we're looking at the reason that in the Gregory case, they were looking at the fact that this was imposed, a decision was made that these people would be put to death. That was a huge focus, and we can't just ignore that.
Right. The decision, they had to put what was happening with the studies was that they were having to isolate the factor. They were isolating they were pulling out all these potential mitigating factors, all these potential aggravating factors in the trial reports that the jury was considering. It was either a jury or a judge. And those actually, and they looked in and they thought, oh, wait a second, this is just racist. This is just racist. And here, we don't have any of those mitigating factors that might have confounded the analysis.
So your challenge is to this act facially, am I understanding that?
No, we've raised it as applied, and Gregory is an as applied sentence, and I can explain. I know facial and I think the state took it as a facial challenge, but the difference, I want to be very careful here because it is facial. It is confusing. Gregory is an as-applied case. And the reason it's an as-applied case, I think, is because the court did not say the state can never put someone to death. And similarly, we aren't saying that death in prison for any combination of 3 crimes is per se unconstitutional. I think that maybe that's why we haven't challenged the 2 strikes because, so we're not arguing that it's facially invalid.
Although your argument would fit with the 2 strikes as well. I mean, if the whole idea is the system is racist, that all of these decisions leading up to charging someone, prosecuting someone, isn't that for the 1st strike and the 2nd strike as well?
I don't have the data for that. The study that I'm relying on, the Justice is Not a Game, looks at the 3 strikes. It does not look, it very explicitly does not look at the 2 strikes. I want to go back to the history of the Persistent Offender Accountability Act because it comes from 1993. The original bill actually failed in the legislature, but with funding from the NRA and the very famous, Wayne LaPierre, 76% of voters approved it. We were the first state in the country to enact such a law. 3 strikes, you're out. It's cute, but it's not cute. So basically, the Persistent Offender Accountability Act is the product of 1990s attitudes that were exploited by racist politicians and media figures. They used racial narratives promising to rid the streets of thugs. The promoters were a local talk radio host and a national politician who later advocated for aborting Black babies. They disregarded socioeconomic issues. They otherized Black citizens, and they weaponized the legal system against Black people. All of this for nothing, because the laws don't actually affect the overall crime rates. And as the study says, and I agree, because we led the nation in this policy, we have a responsibility to lead the nation away from it. Now, one of the ways that I'm aware that this court is also going to have pause about the comparability between this situation and death in prison is that this is not death, or this is not death at the executioner's hand. But I would say it's another way of playing God. It's just sort of the coward's way out. It means death in prison. It's the apex punishment in Washington. It's the sentence for it's the same sentence that the most heinous murderers and rapists get.
So LWOPs themselves are not unconstitutional.
Yeah, that's correct.
And so in order to make a claim that they're as applied, it's unconstitutional here and it was arbitrary, don't you need to have a decision, again, by this individual judge in this case, that we're looking at?
No, I don't believe so, because I believe that if we can show that the law is if the association between the race and the imposition of the sentence is not a matter of chance. So
Do you want to go into your rebuttal?
I always do.
Well, I guess the point is, if you're arguing that the law is simply unconstitutional as it's applied to everybody, isn't that a different argument? And the law is unconstitutional as it's applied here under the facts of this case, and here's why it's unconstitutional under the facts of this case.
I think I can't argue that my client is Black. So I don't think this court wants to hear me argue that you should only say that the law is unconstitutional as to Black people, because that would be
well, you're the one that framed the argument. It's unconstitutional as applied. We're asking you, how are you?
What are we applying it to?
I'm asking this court to do what Gregory did, which is and Gregory is an as-applied case. I'm taking the framework of Gregory, and Gregory, I'm just taking the words of the court and saying that it's an as-applied case. I sense your frustration, but this is not a facial challenge because, as I've said, we're not saying that there's no possible combination. So to get back to what I was saying before, we do have to go back to first principles in a way. And Furman in 1972, Furman is the case that really is talked about in Gregory. And I wasn't alive then. Probably none of you were alive then, but one of the there's 5 concurring opinions in Furman, I'm sure you're aware. And what Justice Stewart said was, these sentences are cruel, unusual, in the same way that being struck by lightning is cruel and unusual. Maybe he didn't say it explicitly, but one of the other justices did say that really the lightning was being Black. And I think that applies the same way here. I mean, so if we want to look at the association between the general population and the sentence, Black people are 8 times, it's at the rate of 8 times the general population in Washington. It's crazy. And if you're looking at the prison population, it's double the prison population. And we already know that the prison population is the product of systemic factors. So it's not even consistent with the garden variety racism of the court system. All right, I'll leave my 1 minute. Thank you.
Thank you.
Good morning, Your Honors, and may it please the court. Gabriel Jacobs on behalf of the state. I'm hoping the court might indulge a quick moment of meta commentary in which I will acknowledge that a majority of this panel has already rejected previously both of the arguments made by Mr. Dugan in this case, and specifically the argument based on Gregory. Judge Smith in State versus Kennan, you rejected this exact argument, noting that the basic statistical studies that were same or similar to the ones Mr. Dugan relies on are too far removed from the advanced regression analysis that the court relied on in Gregory. And then there was, of course, a 97-page analysis compiled by the court commissioner. The state responded with its own counter-expert. The commissioner solicited interrogatories, and it resulted in a really comprehensive record that's missing here. Judge Bowman in State versus Legrone, you also adopted the holding from Nelson that there's no racial disparity in the administration of the POA because there's no discretion. So unless one of you are planning to do a complete 180 from your prior positions, I'm not sure I have a ton to add, but I'll try and use a respectable amount of my time. I would also note that a majority of Division I as a whole has rejected this argument, and all 3 divisions of the Court of Appeals have rejected this argument.
So what do we do with these statistics that tell us that this statute is applied disproportionately to people of color, in particular Black people?
So a couple things about the statistics. First, these statistics are just basic statistics. So with the population to...
You're not going to say that it doesn't exist. It doesn't actually
No,
happen, are you?
well, I'm not saying it doesn't exist. What I'm saying is there's no link between cause and effect. And that's what was crucial in Gregory, was that there was a link between cause and effect. They linked the racial disproportionality to the exercise of discretion at the sentencing phase, whereas here you don't have that cause and effect. And that's why I analogized it to Rivers, which was the fair cross-section case, which had a sort of similar issue. and that you have this obvious racial disproportionality
But you can understand the frustration. Essentially, the argument is that the systemic racism is occurring farther downriver. So it's the police actions and the prosecuting decisions that put all of this into the system, and this is a situation where judges are not exercising discretion, but the outcome is the same because it's coming from some other spot. So what is the answer to that?
Well, the answer is you have to find the source. And if you don't find the source, courts have repeatedly said what the Supreme Court said in Rivers, again, is we know there's this disproportionality, but we don't know where. And without knowing where, we're not going to throw out the jury system. And the same principle sort of applies here. I mean, if you're just going to go on basic proportionality and say what the defense argument is here is once you show disproportionality, you throw out the statute. I mean, what if you find disproportionality in Ag 1 convictions? Do you
They
throw
aren't
out
saying simply once you find disproportionality. They're saying more than that. So that's an oversimplification.
I mean, they're saying that you have an X percentage of people of color, in this case, Black people specifically, and then you have X percentage that's disproportionate are sentenced under the POAA, and that's basically all they're relying on as to ask the court to throw out the statute, or at least as applied, I guess. I had read it as a facial challenge. But when you look at what Gregory was saying, I mean, Gregory, the whole point of it was the arbitrariness. That was what it focused on. And in fact, I read that quote about the strike of lightning being like the death penalty that the U.S. Supreme Court previously said. The whole point was that when you're before a judge deciding whether you're going to be sentenced to death or life, how that decision comes out is going to depend on your demographics, what county the crime was committed, and all these things that aren't really fair for making that sort of decision. Whereas here, when you have the POAA, there's only one place where we know for a fact that the disproportionality is not coming from. And the place where we know for a fact it's not coming from is from the courts, because the courts don't have discretion. So here, it's almost the polar opposite of Gregory, in that Gregory individualized the disproportionality to the discretion of the courts. Whereas here, it's the opposite. We know for sure that's the one place it's not coming from, because the judge doesn't have discretion. So you don't have that variances. I think it's somewhat remarkable. I know that Mr. Dugan doesn't speak for the entire defense bar, but that we've gone full 360, where Gregory was all about the sentencing court having too much discretion, and now they're saying the POAA is unconstitutional because the trial judges don't have discretion to mitigate the harsh effect of the POAA. So now we're on a constitutional seesaw where no matter whether the court has discretion or not, it's unconstitutional.
So when I asked whether LWOP itself is unconstitutional, of course, we've got the different situation with youth, where the courts have held that if it's mandatory and the judges don't have that discretion, that is what makes it unconstitutional, right? So is this like that situation, that it is the fact of the lack of discretion that makes it?
No, I mean, children are different and death is different. I mean, I think there's very clear lines of jurisprudence that those two sort of categories of crime and punishment are different than the ordinary. When you have juveniles, you look at things differently. Punishments for juveniles are, going back not that far to Houston Sconyers. We know that that's different. And we know from Gregory and a long line of cases around the country that death is different. But as for the POAA in general, the Washington Supreme Court, has repeatedly upheld it. I'm not aware of any court that has found it unconstitutional to sentence someone to life in prison for being a serial violent offenders. And again, I just don't understand how the disconnect between cause and effect here could lead to any tenable result. And I understand, to get the kind of studies that were found to be dispositive in Gregory, it's hard. I mean, they're expensive, they're time consuming. You might not get the result you want. And so the defense just didn't do it. But the result is that we don't have any reasonable data on which to base the conclusion that they're asking this court to find. All we know is that we know there's disproportionality in the system somewhere, somehow there's disproportionality. But I'm not aware of any court, including the Washington Supreme Court, that has ever found that by itself a basis to throw out a statute, or in the case of Rivers, a jury selection system. And if that was all, if you disconnect cause and effect, then it's hard to limit where the reach of this sort of argument ends. Because this, I mean, and I don't want to excuse it, but there's disproportionality throughout the system, and it's something that we need to work on. It's something that we need to do better at, but throwing out statutes without any knowledge of why or how that statute is being affected, or why or how it might result in disproportionality can't be the answer.
So now you're suggesting, or what I'm hearing is that this case does not have the right information before us to make that decision.
Well, there's a number of problems with this case. I mean, I haven't even addressed waiver. I mean, you know, I don't think the court even has to address this case on the merits, because a number of cases from around the state have found that when you don't supply sufficient information, there's not really anything for the court to fairly consider. I mean, the state didn't have a chance to rebut these statistics below. The trial court didn't have a chance to address them. So many courts, there's been about 8 Court of Appeals decisions in the state rejecting these arguments, and I think at least 2 or 3 of them did so on the basis of waiver, because these arguments, I don't know if it's these precise studies, but precise or very similar statistical studies were presented for the first time on appeal.
And so you're running out of time. Did you want to address the Sixth Amendment argument?
Though, as to
The Erlinger argument.
Oh, the Erlinger argument. I mean, I don't have a ton to add other than to what this court has already held in its past cases. A majority of this panel has already ruled on the Erlinger case, and I think I probably heard the same briefing you read in those other cases from other people in my office. So I'm not sure I have all that much to add. I did want to add, one thing I did want to address is the statement of additional grounds while I still have a minute left. This is Mr. Dugan's a very prolific litigant. I stood in because of some leave issues during the part of the 5 years of post-conviction proceedings between verdict and sentencing that occurred in this case. Most of these issues had been litigated before. Mr. Dugan had a habit of bringing the same issues over and over again until Judge Schubert finally had to restrict him from filing motions, because he was filing dozens and dozens of duplicative motions over and over again. The state, it's been designated, there's probably 150 pages of briefing that the state filed, because there was a full, almost a redo with the trial part during post-conviction proceedings on the IAC claims. Both defense counsels testified at length for days. So all these things in the statement of additional grounds have been explained. The defense counsel testified at length why they did certain things, why they didn't do certain things, especially with the issue with Maurice Houston as an other suspect that Mr. Dugan has been very interested on for years now. Defense counsel basically looked into it and said there's no defense here. And that's all the record. So I'd ask the court to look at the state's huge amount of briefing in the trial court record as to the statement of additional grounds. It'll make the court's life easier. I'd ask the court to affirm Mr. Dugan's judgment and sentence. Thank you.
Thank you.
All right. The Supreme Court has not upheld the death in prison sentence as to the specific challenge. So I'd just like to address that.
They've certainly denied review.
They did deny review.
Cases where we have made that.
Right. I think that my briefing adds some exciting and new aspects to this. And I think that I don't know, but I hope they will be interested. I don't believe waiver occurred. I think the courts of appeals are misusing the RAP 2.583, because the question is not whether the trial court knew enough to do something about it. It's whether it's obvious on the record. Scott, actually, one of the original cases from 110 Washington Ave, or Washington 2nd, collects cases pointing that out. So I would urge this court to look at that. I do want to address really quickly Furman. The issue in Furman was lack of discretion. Gregory didn't come around and say, you know what, you already said lack of discretion. Now you have discretion. Oh, well, we're just going to throw it in. They found that because of the severity of the sentence, that relief was warranted under the Constitution. And we urged the court to give Mr. Dugan hope and not sentence him to die in prison. Thank you.
Thank you. This matter is submitted. The next case will be the state of Washington versus Emmanuel Kozma.